meeting. So, Christy, if you want to introduce yourself and we can get going.
Okay, great. So excited to see you guys today. My name is Christy Calbos, and I'm a special ed attorney. I've been working in special ed law for about 20 years. I'm based in Atlanta, and I serve the entire state of Georgia. And what we're going to do today is a Q&A. It's an experiment, and we are going to take questions. Some people wrote to me who couldn't be here live. I'll answer those. Anyone who's here live, absolutely answer your questions. If you want to write them in the chat, you absolutely can. Or if you want to raise your hand, I can call on you. You can unmute yourself. Just want to say two quick things. Be mindful of privacy. So sharing your child's name or confidential information about yourself, your family, this will be rebroadcast. There will be replays available. The second thing is that this is not specific legal advice. This is general information. So if you actually need to consult with an attorney to dig deep into the details and get specific legal advice for your situation, you can certainly reach out to me. My information is calboslaw.com, and you can schedule a complimentary consultation, and we can go from there. So is there anyone here on the call that has a question? You can raise your physical hand. You can raise your emoji hand. If you don't know how to do that, if you go down to and you click on the bottom of your screen, there's something called reactions. And then there's a little bar that says raise hand. You could do it that way. But yeah, I see Sarah. Sarah, you want to come off mute?
Sure thing. How's it going? Thanks so much for doing this morning.
Of course.
Yeah, so my daughter is 10 years old. She attends a Fulton County school, and due to some very extensive medical needs, she has a IEP mandated one-on-one nurse. Fulton does not hire or employ their own nurses to fulfill IEP needs, so they contract out with multiple agencies. And we've had challenges staffing her case for years, both home and school. I realize this is just school related. Obviously there's a pretty extensive nursing shortage. But she's missing, over the course of her school career, she's missed hundreds of days. We are now consistently going to be missing 2 days a week. And I'm just wondering what, recourse I have to holding Fulton County responsible for staffing this. And much of it comes down to pay. If they were advertising a job at X number of dollars an hour, I'm quite certain they'd be able to staff it, but we know that that's not the case. So they are not fulfilling the mandated staffing that is necessary in her IEP. So sorry if that was long-winded. Does that all make sense?
Absolutely. Great detail. So the first thing is that the IEP is the equivalent of a legal contract. Mm-hmm. So when you go to an IEP meeting, it's a business meeting. It's a legal meeting. And the most important thing is to understand that whatever is written in the IEP has legal force, and it can be enforced. So you have several options. You could request what's called a mediation through this Georgia Department of Ed. And the mediation would be handled by a Georgia Department of Ed mediator. It would be at no cost to you. They would arrange it at a date and a time that you and folks from the district could meet. Sometimes they're in person, but I think since the pandemic, they're doing a lot of these virtually. You would fill out the form, request a mediation, go to the mediation, and you'll be sitting down with higher level administrators who are in a position to actually move the needle on implementation of an IEP. Okay. So at the end of the mediation, if you are able to reach an agreement, that will be documented in a contract, what's called a settlement or a mediation agreement. That is also enforceable in court. And the district will implement the terms of the mediation agreement, whatever it is that you guys came up with. So that's option one, mediation. Second option is you can file what's called a formal complaint. Now, sometimes people call this a state complaint. And the reason is that you are filing it with the State Department of Education, and that form is available online at the Georgia Department of Education as well.
Can I just ask a clarifying question real quick? So the
Yeah.
mediation is through Fulton County, and the escalation of that is through the State Department of Ed. Is that what I understand?
No, the mediation is through the Georgia Department of Ed. So you are exercising your parental rights by asking the State Department of Ed, the governing agency, to get involved. So you are filling out a mediation request. You can find that form at the Georgia Department of Ed website. Okay, same thing for the formal complaint. You fill that out. That requests a little bit more information. And that way that works is you fill it out with the facts and the resolution that you're seeking, whatever the resolution is. On that form, there's a box that they ask you to check. Do you want to go to mediation? Yes or no? If you check yes, the same process will unfold. Someone from the Georgia Department of Ed will call you, will schedule a mediation. You'll sit down with higher level administrators from the district, try to get to a settlement agreement or mediation agreement. It should be confidential. It'll be binding, legally binding. If for some reason that mediation falls apart and you're not able to reach an agreement, what then happens is an investigator from the Georgia Department of Ed looks at your case, goes on a fact-finding mission, and writes a ruling, writes a decision. That usually happens within about 5 to 8 weeks. So while you're trying to line up your mediation, an investigator is already hitting the ground running, just in case your actual mediation does not come to fruition. An investigator will have responsibility for it. The investigator may or may not agree with your wish list of your resolutions that you wrote there. So for instance, if you wrote that you want Fulton County to start paying $25 more an hour for a nurse, the investigator may or may not agree with you. So once the investigator writes their ruling and their decision, you cannot appeal that. That's final. Okay. And so that's what's called a formal complaint. Now, one thing to know, Sarah, is that has a 1-year time limit. You can only list alleged violations that have occurred within the last 12 months. Okay, so you have a time limit there. And every day that rolls forward on our calendar here in October, we're losing a day from October a year ago. So today is the 17th of October. You can file a formal complaint with allegations that go back 12 months ago, but every day we move forward, we're losing time on the back end. Okay. Third option is a due process hearing request. This comes through, again, the Georgia Department of Ed. You find that form online, a due process, DUE process hearing request. Sometimes we call that a due process complaint. You fill out that form, and this time you're requesting a hearing before a judge. That form will also have a box on it that will say, do you want to go to mediation? And it will ask you about something called early resolution. So what happens when you request a hearing before a judge is you have 2 chances to try to resolve your case before you end up in court. One is called an early resolution session, and the other is a mediation. If both sides agree, hey, we're not going to worry about early resolution, let's just go straight to mediation, then you'll meet up in mediation within about 30 days of the time that you wrote the complaint and filed it. And the same process, you'll have a mediator. It's free of charge. The mediator will try to help the 2 parties come to an agreement. It'll be documented in writing. The case will be resolved. Now, if it doesn't resolve, you will end up going to court. A judge will have responsibility for hearing your case in court. And that will be a situation where you're the plaintiff. You have to present evidence, witnesses with live testimony, documents, right, that you have to be able to authenticate in court. that particular type of hearing requires a slightly higher level of knowledge. Most parents want an attorney to help them if they're requesting a hearing. And then the judge, after hearing the case, will write an opinion. And in that particular case, if you don't agree with the judge's opinion, you can appeal that. You can appeal that to a higher court. So you wrote, my understanding is the state wins 99+% of due process hearings. Unfortunately, what happens with the statistics is that we have seen over the last, I don't know, maybe 10 years, a higher percentage of school districts winning due process hearings. That could be due to a number of different things. It could be due to the fact that perhaps the parent isn't coming into court with really compelling evidence or really persuasive experts. It could be many parents are going in unrepresented by an attorney at all, whereas the school district may have an attorney. And it could be that cases are being filed and heard that aren't necessarily winning cases. So what we see is that parents from the outset are typically scrambling to try to find the evidence and the experts to support their cases, because in court, a parent taking the stand to testify doesn't hold the same weight as an expert that the parent has hired taking the stand to testify. And we call these hearings a battle of the experts. So your plaintiff is hiring experts, the school district has their experts, and they're taking the witness stand and they're walking the judge through the facts and their opinions, and then you leave it to the judge to determine what the outcome will be of the case. So in your particular case, you have three options. You can request a mediation, you can file a formal complaint, or you can request a due process hearing. And those are the ways that you would go about seeking not only retroactive assistance for missed education due to the lack of staffing, right? So that's called compensatory education, compensatory tutoring. And then you would also address prospectively, what are we going to do to fix this problem moving forward? So hope that answers your questions there. I see you have one more question. Can due process be class action or joint filing with multiple families? Typically, we don't do that because it's an individualized consideration. What has this child under this child's IEP missed in terms of specially designed instruction for their goals and exposure to the general curriculum? Not to say that there aren't class actions filed, but typically in a due process hearing on the scale we're talking about, you're trying to recoup your daughter's missed education for what we call a violation of IDEA. Your daughter's IEP wasn't implemented. You have very specific facts. And so what you're trying to do is recoup lost educational opportunity, and you're trying to fix the problem moving forward. And your remedy, Sarah, may look different than other families. Your remedy may look like, tuition to a private school. It may look like a private tutor coming into your home. It may look like tutoring that unfolds over the next 2 years to recoup lost opportunity. And the district may decide, we'll have to come up with another solution to deal with the nursing shortage. One thing I want to say that's applicable to anyone who's on the call live or might be listening to the replay, this same scenario is applicable to anyone who doesn't have a speech language therapist serving their child, a physical therapist, an occupational therapist, special education teacher. The staffing requirements that are in your child's IEP are required, and the remedy for a child not receiving a service that's written in the IEP is what we call compensatory education. And so you're always looking to see, what can I recoup that we've lost? But I wholeheartedly recommend that you also enter into a settlement agreement that requires the district to have a prospective remedy available. And what we're dealing with right now is labor shortages, right? Labor market shortages for many special providers. So Sarah, I hope that helped. Did that answer your question?
Yeah, that was really, really helpful. I
Great.
appreciate it.
Great. Okay. Good luck.
Okay. Well, I'm sorry. Just one last question. Because each of those option has a mediation like intermediary, like why would you go to the third option if you're just automatically going to be dumped into mediation anyway? Or you're saying that you can decline mediation by not checking that box and go right to the due process? Is that kind of what I understood?
So for due process, you have to participate in either the early resolution or the mediation.
Okay. Okay.
So what the law requires is that parents give one good faith attempt to resolve the issues before going to court.
Got it. Okay.
And in terms of strategy, and there's legal strategy depending on which of those three you choose. Mediation alone, the first option, doesn't really have any post-mediation teeth to it. There's no bite to that. So if you fail at mediation, you're right back at square one. There's no one that's going to pick your case up and run with it after mediation has failed. That's option one. In option two, which is the formal complaint, if mediation falls apart and you don't get a written settlement agreement, at least you know a Georgia Department of Ed investigator is going to take your case forward. And the same is true for due process. In a due process filing, if mediation fails, you know that your recourse is a step two, which is I'm going to now go to court and present evidence to a judge and let a judge be the decision maker.
Makes a lot of sense. Thank you so much for that clarification.
You're welcome. All right. Anyone else have a question that's on the call? Feel free to come off mute and ask or raise your virtual hand or physical hand. Don't be shy. And I have a list of questions too from folks who've written into me. And the very first question was exactly what Sarah asked me. What is the enforceability of an IEP? And so I'm so glad you asked that, Sarah, because it helps parents understand what do I do when I have an IEP and a component of it is not being enforced. Okay, second question is, what do I do? Again, same topic. If my speech services aren't being delivered, my occupational therapy services aren't being delivered. Same problem, same solution. Look at either mediation, formal process hearing. Sometimes you can actually go to an IEP meeting and say, listen, these services aren't being delivered. What do I need to do about it? Unfortunately, IEP teams are often not in a position of authority or problem solving for that, because if it's a staffing issue, we're talking about human resources getting involved. And so typically what will happen is the team will say, we know, we understand that you're not getting the services your child's not getting the services in the IEP. We'll make it up to you. We'll give compensatory education, compensatory services at a later date once we find someone. What I do tell parents is, if you're not getting a service like speech or OT or PT, one of the most important things to say to an IEP team, or if you're filling out a complaint form, is to offer the district the solution of contracting with a private speech language therapist or a private occupational therapist as a stopgap measure to help get through the hiring crunch. Okay, so that's one idea. Another is many parents already have a private speech therapist or a private occupational therapist. It may be nearly impossible for that person, that private provider that you have, to find time in their schedule to squeeze your child in for additional services. But sometimes the district will say to a parent, if you can get your private provider to make up some of these sessions from the past, or just pick up with sessions we're supposed to be providing now, we'll reimburse you or we'll contract with them. So you want to think outside the box into how can we possibly get the services now? And the reason the emphasis is on now is because if we go 3, 4, 5, 6, 8 months without these therapies, it can be problematic. Your child's development will, be delayed if they're not receiving the services that the IEP team thought were essential, right, for their progress. So just accepting compensatory education as a remedy is not necessarily the best thing for your child in the present moment. Okay, so another question, you guys feel free to jump in. Otherwise, I'm just going to go down this list of questions that folks wrote to me that couldn't be here. Another question is, how do I get a parapro? I get this question a lot. A lot of parents call me and say, my child really needs a one-on-one parapro or needs adult supervision. There's a difference between just having a class paraprofessional and having a child in their IEP. It states one-on-one paraprofessional, and it's critical that parents understand the difference, and it's critical that the IEP note the very specific difference. A one-on-one parapro is someone who has been hired and is being paid the salary and the benefits package solely for your child's IEP services. That parapro cannot serve other children, cannot be pulled out of the classroom to go do lunchroom duty, cannot be called on to help with, hallway transitions or go to another teacher's classroom during the day to pinch hit for another teacher or another class. That one-on-one parapro is your child's assistant, right, all day or during whatever portion of the day the IEP says one-on-one. Now, a class parapro is someone who is added to the class. You'll go to IEP meetings and sometimes hear teams say, well, we know that extra support is needed in the classroom. We're going to add someone to the class. So they're going to add another adult. There may already be a teacher or two teachers. There may already be a parapro, a class parapro in there. What they're saying is that they're going to have staff added, but remember, that person can be pulled for other duties besides what your child may need at any given point in time. Why is that an attractive option for school districts? Because flexibility and being able to share resources and maximize the efficiency of a resource is number one priority for school districts at this point. There's a real problem in the labor market in trying to find qualified candidates to be paraprofessionals. Parents are calling me who have a one-on-one para written in their children's IEPs, and the district cannot find anyone to fill those positions who would be a suitable candidate. So really what we're looking at is if they can find anyone who would be willing to serve as a para, they're going to try to use that person in as broad a capacity as possible rather than one-on-one. Now, it's very difficult to persuade a team to give you that kind of dedicated resource that can only be used for your child. How do you go about doing that? Well, first, you have to make sure there's adequate data, right? That we've had X number of suspensions or aggressions or elopements or non-compliance tantrums. You're really looking for data over, a significant period of time, maybe 6 to 12 weeks worth of data that indicate that your child just absolutely requires that kind of one-on-one adult attention and support in order to make progress. So it's really a necessity, not a nicety. So what you're looking at is asking in an IEP team meeting a very formal request. I am requesting that the team allocate a one-on-one parapro to my child. I'd like it in the IEP. What is for that? And of course, you're recording all of your IEP meetings and you're walking through the process. If the IEP team responds, we'll take a look at it. You can't stop there. You need to ask a follow-up question. What does that mean? What is the process? Are we going to start taking data? What type of data? Who's taking the data? How frequently will you be taking it? What are we looking at? Are we looking at just academic compliance? Are we looking at behaviors? We need to be taking data on XYZ. Write all of that in the IEP and then decide how many weeks are we going to be taking data for, and then create a calendar follow-up meeting. You'll come back to the team meeting and review that data and look at whether or not the data rises to the level of your child requiring a one-on-one. If that happens and you go back to a team meeting and the data shows, yes, your child needs a one-on-one parapro either for the full day or a portion of the day in order to make progress on behavior or communication or academics or self-help, at that point, then human resources will receive, the notification, hey, this elementary, middle, or high school needs candidates to interview for a one-on-one para. Then that process begins. So you see, we've already spent a good amount of time collecting data. Then the hiring process begins. And that's where sometimes this moves at a really slow pace because school districts have had a difficult time finding qualified paraprofessionals to interview, right? So human resources advertises for it, principals or assistant principals interview candidates. If there's a good match, then that person will be trained and will come into the classroom and work with your child. That whole process can take months. So, but the key is that you get it started and that you not allow more time to lapse while you're waiting, right, for someone to talk about it, think about it, consider it. All decisions about your child's education, when it comes to specially designed instruction, support, and services, need to be made in an IEP team meeting, and they need to be documented in the IEP. So the last thing I'll say is that before you leave an IEP meeting where you've had a discussion about services, a parapro, etc., you want to ask whoever's taking the meeting minutes or handling the software, typing into the document, you want to say, could you please read back to me what you've written about our decisions and our dates and our timelines here today at this meeting? I just want to be sure that I have it right in my notes and that the IEP itself reflects what we've decided on. So that's a tip for parapros. Okay, I'm going to pause for a second and ask if anyone has a question. If you've put a question in the chat, I see Sarah and Jennifer have been talking about school nurses. Don't see anybody else that has written a question there.
You already spent some time with me, so if there's others, I will be happy to step back. But I'm curious, my daughter's primary eligibility is deafblind. So I know that automatically limits the amount of kids and it dictates staff ratios. Is that correct?
No, I mean, every child is different. So a child that has vision or hearing impairment, the IEP team has to come together to determine based on your child's needs, which dictate goals, right? So it starts with a list of needs, right? And then from there, the team creates goals. And then goals drive the decision about where your child is placed. Your child could be placed in a general ed classroom with 25 students and a nurse and a parapro. If your child is capable of achieving the goals and meeting the curriculum requirements in a general ed setting. And then from there, you're looking at other options like a co-teaching classroom. You could be looking at what we call a resource room or a small group classroom. But typically what we're looking at is a highly individualized development of an IEP based on if your child has no cognitive limitations, if your child already knows Braille and doesn't need orientation and mobility and is on grade level, then you might be looking at, and what I encourage parents to do is make sure that you're not accepting a one-size-fits-all cookie cutter predetermined program for your child. Your child has a presumption of that the IEP team will look at the least restrictive environment for your child. And by least restrictive environment, what I mean by that is an environment that has the least number of disabled students in it. So we start at general education with no supports. Sarah, does that make sense?
It does, but I was always under the understanding deaf blind from a state level, regardless of any other considerations, had its own standards when it comes to the size of the classroom. That the school
They
gets
might.
more funding and has less, like just by virtue of her being deaf blind, her class can only be X number and has to have certain staffing. So I'm just wondering if that's another piece of evidence on my part when we're talking about not being able to staff that one-on-one nurse.
Yeah, I don't know. I would have to pull the policies and look to see if indeed there is a standard size, class size for deaf blind. It's been a while since I've had a client who has had both of those exceptionalities, so I'd have to look that up to see. And then from there, I think the most important thing for you is really looking at how, I'm not sure that would actually be a point of evidence that you would be able to use in an argument about the special needs nurse. But again, we're going a little bit deeper into details here that I would probably need to take a look at outside of this webinar. Yeah. Okay. Valerie, do you want to come off mute and I'd be happy to answer your question?
Oh, do thank you. It's a quick question about least restrictive. Is a one-on-one para considered more or less restrictive than like an OI classroom with push out into gen ed?
Okay. All right. So let's first talk about what least restrictive means and how it's used. That term is often misinterpreted by school districts to dissuade parents from asking for a one-on-one parapro. And I want to be careful talking about this because this webinar will be available for replay. And again, I want to emphasize every situation is different, and this is not specific legal advice for anyone. This is generally speaking.
Okay.
Least restrictive environment, Valerie, refers to a term in IDEA, which is the federal special ed law, that says that children with disabilities, with IEPs, have the right to be educated to the maximum extent appropriate in the least restrictive environment. It doesn't refer to staffing or personnel. It refers to an environment. And what is the least restrictive environment? One that has as many neurotypical general education students in it as possible. So what the least restrictive environment, starting on the continuum, is a general ed class with only one general ed teacher, and there are no students in it with IEPs. So you start in that environment when the team is talking about, okay, we've just developed the goals and where do we place this child? The child may be able to go into a general ed classroom and have a one-on-one para, might also have additional support staff with them. The fact that your child may have 2 or 3 support people with them does not impact the LRE. However, teams will say frequently, okay, well, that's restrictive. We don't want to give your child a one-on-one para because it will restrict your child. That's not the LRE. What they mean is that they're afraid a one-on-one para will inhibit socialization opportunities with peers, right, in any setting that they're in throughout the school day. That is not an LRE argument. That is a socialization argument. And a good para is going to fade back and allow, first, if your child needs socialization support and services, a good para and teacher team will help foster that, build the skills, but then a good para fades back as much as possible so that there's not an adult hovering there with a child that would naturally sort of impede other children's natural curiosity and friendliness to come up and socialize. So does that make sense?
It does. So just to recap to make sure I got it, least restrictive refers to environment. So a gen ed and then OI would be more restrictive, obviously. It doesn't look at the resources that are assisting the child, whether it's in gen ed or in an OI or pulled out or any of that.
Correct.
Okay.
You got it. Yeah. Got it.
Okay, thank you.
You're welcome. Okay, anyone else want to raise their emoji hand or or just come off mute and ask a question? If you're not able to find that raise hand button, feel free to just come off mute and jump in. Yep, looks like Jennifer. Hi.
Hi. Would you be able to briefly discuss the, I've been reading about the possibility of where a child with an IEP is taken out of public school and they're able to take some amount of money from the school district to go to a private school. Would you be able to briefly discuss that program and how the funding is determined?
Sure. So I think what you're referring to is the layman's term is special needs scholarship. Okay. And any of you who aren't familiar with this, you go to the Georgia Department of Education website. They have an entire department and a program manager. Aisha Parks is her name. And she, and that website has all the information about the special needs scholarship, including a calculator. You enter your child's information into it, including the last school that they attended, and it will show you the amount of funding from the state portion of your child's education that you could use and apply to tuition at a private school. And there's also a long list, schools throughout the state of Georgia that accept the special needs scholarship. Now, the truth is, Jennifer, on that website, there is a host, just a huge amount of information about the funding formula. Okay. And so there is actually, I think, an 8 or 9 page document that shows you, that breaks out how much is allotted for a one-on-one, how much is allotted for a self-contained classroom, how much is allotted for speech 2 times a week, 3 times a week, OT. They start adding dollars. So, and I'm just making this up because I don't know exactly what all the allotments are, but let's say that speech 2 times a week is worth $600, and you start growing from there. Typically the amount ranges anywhere from $3,000 on the low end to about $14,000 total. Now, the funding formula can shift a little bit from year to year, depending on what the legislature does with education budgets. But in general, it stays at around that amount. So let's say your child qualifies for $8,000 in the special needs scholarship. It may shift a little bit. It may shift one year up to $8,300, and then another year it may shift down to $7,800. But in general, it kind of stays in that range. So, and it's based on your child's last IEP that was uploaded to the Georgia Department of Ed website, where they basically run it through the algorithm, and a dollar amount is assigned based on all of those different categories that are in an IEP. So you can find all that information. It used to be very difficult to determine how they funded it, but they've come out with some documents that they have available to the public on that website. I have to tell you that even looking at it, it becomes confusing to try to see how they do it. But one thing I want to say is that once you've pulled your child out of public school, you have 30 days. I think this is still the current rule. All the rules are written on the Georgia Department of Ed website to select a school, enroll your child, and start that funding flowing to that school. You only, in the past, this has been true, you only ever have a 30-day window. So you have to be careful if you pull your child out to homeschool and you don't enroll them in private school. There's rules about how you requalify for your special needs scholarship. So I'm going a little far afield of your question there, but does that help?
It does. So you said that it's the state funding portion. So when I did a calculator at some point, and it showed some number that was so low, it was like $6,000 or something. And I know that, like, if you look at how much each school spends per pupil, or how, like my school was like $11,000 is how much is per pupil spending. So I was confused why that, because to me, I thought, okay, well, that means that we would, if $11,000 is being spent per pupil, then that would be $11,000. But then the calculator said like 6. And so I was just confused about that part.
Yeah, I don't know. I don't know why there would be a difference there. I would call Aisha Parks. I would email or call her and ask her to walk you through the funding, and make sure that there's not a mistake with the allotment. And sometimes that could be an average of 11,000 spent, and sometimes those are local funds that are kicked in, or federal funds, etc.
That's what I was wondering if because, I mean, obviously the counties through their property tax dollars fund, so you know what role that plays. But now, is this process automatic? Like, is he automatically eligible because he has an IEP? Okay, so there's no qualification like for some other things might be where you have to prove the education isn't. I'm sorry, I'm a special ed nurse and I have some kids in the room who are talking to us right now. But so it's not like other programs where you have to prove that your child's not getting what they need in the school system.
No, you're automatically, children with 504s now, 504 plans are also eligible for their allotment. You know, nothing you need to prove. You just, you follow the instructions that the Georgia DOE has outlined for claiming your funds. Can I just give a quick tip here to anyone who's thinking about pulling their child out and putting them in private school? Please be so careful that the private school actually can provide the services and supports that your child needs. I'm hearing stories like throughout the pandemic where parents pulled their kids from public schools, took their special needs scholarship money to defray the cost of tuition, signed binding private contracts with private schools, only to be disappointed and heartbroken when the private school either didn't stay open during the pandemic or now post-pandemic, were not able to provide the services, or simply told parents your child needs things that we don't have here, and we're going to have to dismiss your child. And the parent is stuck with a contract that says they owe a percentage of tuition or they've lost thousands of dollars. And so you want to be real careful when you're entering into a private contract. Private schools don't have the same legal obligations that public schools do when it comes to special needs students. That's a private contract versus federal and state law mandating what your child is entitled to. And as we're talking about today, under federal and state law, you actually have pathways for resolution if your child is falling further behind or not getting the services. You would not have those same pathways available to you if you go to private school. So just want everybody to be careful about that. So Jennifer, did that answer your questions?
It did. I'm trying to figure out what to do where he's not getting what he needs from the school system. And I see that that's true of so many kids. And so I don't know, I worry that like, I can't do this because there's so many kids who are not getting what they need even more than him that, so that I'm just trying to figure it all out.
Yeah. Well, good luck. Good luck. These are tricky decisions. There's a lot of criteria. So let's see. Someone has asked a question. Have I helped a child in Gwinnett County with an IEP and helped the child get a one-on-one? Yes. What's the difference between a parent and aide? Really no difference, just different terminology. My child's elementary IEP team in Duluth said that only the teacher teaches, the para does not teach, but only tells the child to stay on task. This is true. Yes. A paraprofessional is not allowed to give what we call primary instruction. So the teacher has to do the teaching, and then the para can reinforce, redirect, repeat, etc. It could be that during the pandemic, parapros might have been pinch hitting in ways that they were not supposed to. You said you've seen his online para during the pandemic teach him math. My child really wants to return to a classroom with typical peers. His parents want the same. Children in his class have behaviors and bully him, say racist, harassment things to him. If you cannot speak well at an ASD level 3, you feel it's not right for him socially and mentally. So what I would say about this is that your child's placement, the actual level classroom, is dependent on the goals that are in the IEP and your child's level of need. And if you want to change your child's placement, you have to go back to an IEP meeting, look at the data to see what is your child's level of need, level of functioning. We also call that a present level performance. Create goals that accurately reflect your child's need, and then take a look at their other needs as well: communication, self-help, behavior. And from there, the IEP team and you will discuss, what does each level classroom offer? If one classroom is too restrictive, doesn't offer enough support, and another offers too much support, sometimes districts will veer towards more support rather than less. Why? If they give a child insufficient support in a classroom and the child doesn't make progress over the course of an annual IEP, parents can request a due process hearing. You can go to court and say to a judge, have your experts explain, not enough support was given. My child did not make progress on these goals. Let me talk quickly about bullying, because someone actually wrote to me about that. And one of your questions here is about bullying. There are a lot of rules and regulations around bullying. You want to document it in writing in what's called a Gebser letter, Gebser. You can Google Gebser letter and you would document the bullying and you put the district on notice about the bullying. And you need to go to an IEP team meeting, and on the record, as you're recording the meeting, talk about the social and peer interactions and talk about what your child needs in order to self-advocate. You want to come at it from the perspective of, you're not necessarily looking for a bodyguard for your child, but you want more adult supervision. You want your child to be encouraged to do more self-advocacy. Maybe additional people need to be added to the classroom to kind of monitor peer interactions. Maybe during unstructured times of the day or during the class. There's a lot going on there. So I really think that bullying has become a huge issue post-pandemic. I get a lot of calls about it. It's very difficult to address, and parents need to document it in a Gebser letter and get to an emergency IEP meeting and follow up. All right. So I'm seeing in the chat here, CP, you wrote a lot of information. I'm not going to be able to go through all of the details there with you. But if you'd like to schedule a consultation with me, that's probably the best thing to do. You can go to my website, calboslaw.com, and you want to Google Gebser letter, Gebser. There's no form. You're going to write a letter, but you can see lots of examples of Gebser letters for bullying. So is there anyone else who has a question that wants to come off mute? Or if you've put something in the chat and I haven't seen it, feel free to draw my attention to it. I've seen CPs. Looks like Barbara has asked, what dictates the location of a child in a restrictive versus not restrictive classroom? So what happens is you start an IEP team meeting with a review of where your child is functioning in several domains: behavior, communication, academics, self-help. Those are called the needs. What does your child need to learn in those areas? For every need that you have, you write a goal. Now, your child may have a very long list of needs. If a child has a very long list of needs, the IEP team will not write 50 goals for each one of those needs. They'll try to pick the top 10 to 20 that are the most important, fundamental developmental skills that they want to focus on. Step 2, write the goals. Step 3, decide what type of classroom and teacher and environment will best support your child in mastering those goals. So if I've written a lot of goals for academics and my child has a learning disability and has ADHD and also suffers from anxiety, and we've written goals to address those needs, is it a smart idea to put a child in a general ed classroom with no support, with no special ed teacher? The team would start with the question of, is there anyone on the team that believes that this child could master these goals and make progress over the next year in a general ed classroom with no special ed support? The answer is no. Then they go to the next rung on the ladder, if you will. Now we go up to, do we need special ed consultation? for the general ed teacher? Do we need collaboration? That's the next rung up, which is a general ed teacher collaborating with a special ed teacher. Sometimes we call that co-teaching. They're both in the classroom at the same time. From there, we might look at a small group classroom, also known as a resource room. Could be one special ed teacher and 5 to 15 students who all have IEPs or 504 plans, depending on their medical needs. And from there, you're progressively becoming more and more restrictive in terms of the number of non-disabled peers. You go all the way up to self-contained, and that is a little bubble. A self-contained classroom is a classroom that doesn't have general ed students in it, and they all move together throughout the day as a little pod. They're self-contained, contained unto themselves. And some children have IEPs that are a mix of all of those different placements that I just talked about. You may have a child that goes to small group for math, because math could be a struggle, but they're in co-taught with 2 teachers, special ed and gen ed, for science and social studies. You may have some children that are in co-taught classes all day and have a parapro assisting them, or a classroom aide. So what dictates whether it's a restrictive versus non-restrictive is an individualized consideration of your child's needs, goals, and a selection of a combination of different options available to the team to make sure that for that subject matter or that communication need, your child is receiving the support that he or she needs. And remember, they're always focused on making sure that they're providing adequate support for mastery of the annual IEP goals. And we touched on this in the beginning. If your child does not master IEP goals, there are legal pathways available to you. Okay, so what that means is that the IEP has to be reasonably developed, reasonably calculated, rationally calculated to provide your child with sufficient support so that they can master the goals that you write at that annual IEP meeting. If I say to you, we're going to run the Boston Marathon 6 months from now, right? And that's your goal. And I commit to you as your trainer, you're going to master that goal, but then I don't give you the right nutrition, training, equipment, shoes, and course to run every day, and I don't support you, and then you arrive at the Boston Marathon and you're unable to complete and you didn't master it. The same is true for an IEP team. They're looking at, what do I need to give this child so that they can master this goal, so they hit the target. One thing I want to touch on as we're wrapping up here is that you have to look at your IEP progress reports. Look at those. They come home on the goals. They should be coming home. If you're not getting them every 9 weeks, please go to an IEP meeting and ask that your IEP progress report come home every 9 weeks. Look at the statistics. If you started with a baseline, a starting point of 20% on a goal, and you are halfway through the school year and you're trying to get to 80% by the end of the 12-month period, you should be at a fairly good pace. That needle should be moving in the right direction to hit mastery of 80%. Or if the goal is written on 4 out of 5 trials and your child started the IEP at 1 out of 5, but the needle's not moving in the right direction, or it's not moving fast enough to hit mastery at 4 out of 5 by the end of that IEP cycle, call an IEP meeting. Sit with the team and say, did we get the right formula? Do we have enough going for us now with this combination of placement and services and support so that my child can actually master these goals? If not, we end up at the end of the year and we have a child that hasn't mastered critical goals, and we've really lost that time. We've lost that opportunity, and it's hard to get that time back. All right, I have one more question here about discipline. Someone had asked about discipline. What is the difference between in-school, out-of-school manifestation, determinations, and tribunals? And very quickly, in-school suspension is where a child stays in the building and continues to receive education, not only on the general curriculum, but also on their goals. Out-of-school is where you actually get a notification that your child has to stay out of school. They are suspending educational services. Children with IEPs can be out of school suspended up to 10 days in a school year without needing what we call a manifestation meeting. Manifestation meeting is where the team gets together and says, we're about to exceed the 10 school days of OSS, or we'd like to move your child to a different placement. And we need to ask ourselves, was the challenging behavior, the misconduct, a manifestation of your child's disability? And if the answer is yes, it was a manifestation of your child's disability, then the IEP team does not move your child and instead looks at, do we need to do a revision of a behavior intervention plan? What else do we need to do to the IEP to help make sure that your child's behavior is addressed at school? If the team decides, no, there is no connection between the misconduct and your child's disabilities, then they are allowed to discipline your child the same way that they would a general ed student. So my suggestion always to parents is, if you have to go to a manifestation meeting, be sure you consult with an advocate or an attorney. That's a very important meeting. They hold them very quickly. Your child can get in trouble on a Monday, and all of a sudden on Wednesday, you find out they're having a meeting at 2 o'clock in the afternoon. So you always want to say, I'm going to need more time to prepare. And you always want to get in touch with an advocate or an attorney, especially if it's a more significant conduct issue. Okay, so we have about 2 minutes left, and just scanning through the chat to see if there's anything that I can answer really quickly. Oh, thank you so much, Kimberly, for putting my email address and my contact information in. And yeah, I'm more than happy to consult with any of you. Feel free to sign up for a complimentary consultation. We can go more in depth on any of your concerns. If you have any questions, be glad to answer them there. CP, it looks like you've got a lot going on, so I encourage you to touch base with me and get yourself on my private calendar. So anybody else have any last minute questions as we count down? Feel free. All right. Well,
A
I
real quick
appreciate
one.
you guys. Oh, okay. Go ahead, Valerie.
Sorry. I love the idea about the IEP progress report, because I don't feel like we get a lot of feedback there. That's different than the report card, right? So
Right.
the report card, okay, so this would be specific to each goal in the IEP. And is it something that I would expect them to just send home? Like, I don't need a meeting, right? An IEP
Correct.
meeting. Okay.
Correct. So IEP progress reports are required by law to be sent home at a minimum at the same time they send home your regular report cards. So if your district sends home report cards twice a year, then you would get 2 IEP progress reports. I like parents to receive them more frequently. I usually go to an IEP meeting and ask, can we speed up the frequency of my IEP progress reports to every 9 weeks? Because if you're waiting 16 weeks to take a look at your IEP goals, it may be too late to really get traction and change up that IEP to make sure that your child actually masters those goals.
Okay. All right. Perfect. I'm going to ask for that. I think we do quarterly cards, so I'm just going to ask for that, I think, to start and then see how that goes.
Great. Good, good. Glad to hear that. Kimberly, I think that's it we're at the top of the hour, and I'm so appreciative of Focus hosting me as always. I just want to encourage anyone on the call, if you're not subscribed to Focus's newsletter and you're not engaged, one of the best organizations out there for families, really deep, rich support. So please get yourself signed up with them. And Kimberly, thanks again for hosting me.
Absolutely. Thanks so much, Christy. Barbara asked where you can get the recorded workshops. I will drop a link in the chat. This is where Focus posts all of our recorded workshops, but we will also send a link to everyone who was in this meeting to the recorded workshop, to this specific one. But all of our workshops get recorded and posted to our website. So the link for that is right in the chat. So thank you so much, everyone. And thanks so much, Christy.
Thank you. You guys have a good day.
You too.